Hi, everyone. Welcome to a special K&O Gates conversation with the legendary and iconic mergers and acquisitions lawyer, James Freund. I'm David Edgar, and I'm a corporate partner with the global law firm K&O Gates. In today's discussion with Jim, we talk about his 30-plus years experience negotiating some of the most challenging M&A deals, and we're going to talk about some of his favorite negotiating tips that he learned along the way. I hope you enjoy the discussion. Let's get started. Jim, thanks so much for joining me today.
Good to be here.
I think when I first reached out to you, it might have been a couple of years ago, maybe the summer of 2021, and I think I titled the email that I sent to you, "Thanks, 25 years too late," and I sort of feel that same way now talking with you. I wish I had reached out earlier, but I'm so happy that, we've had a chance to talk over that 2-year period and share some stories and interesting things about the M&A world. And so I'm really glad that you're able to talk with me.
Well, it's been a pleasure for me.
Well, thanks, Jim. I guess I would normally say start at the beginning, but I kind of want to start maybe a bit in the middle. Most of the people listening today, I think, will know you from the outstanding work that you did with Skadden over the many years, and of course the wonderful book Anatomy of a Merger. But I wanted to just get a feel from you. Why did you pursue law and get into law school and then decide to do mergers and acquisitions?
Okay, I'll talk about that. I graduated college, Princeton, in 1956, and I was facing 3 years in the Navy at that point. I had one of those NROTC scholarships school, and I had no idea what I would do in life. I wasn't even thinking about it during the college. I figured I'll decide when I'm in the Navy. Maybe I'll want to stay in the Navy. But after 2 weeks on the icebreaker that I landed on, I decided that was not a good decision. So I was not going to be a Navy officer. What was I going to be? I never thought about being a lawyer, but I did get involved on the ship in representing defendants in special courts-martial, guys that went AWOL and such. And I enjoyed that. The only thing I really enjoyed in the Navy. And it was only one book to read, and I read it. And so I applied to a law school from the Antarctic. I like to say I got into Harvard on a geographic preference, beating out 3 penguins. I didn't like law school, and I wasn't happy at the first firm I went to. There was not enough business to generate any activity here. So in 1966, I became an associate at Skadden Arps. I hadn't heard of them. Sounded like a guy falling down a flight of stairs. Skadden Arps, blump, blump, mark, flump. I was the 17th lawyer. Firm was not widely known, and it was not very profitable, but I sensed that they were hungry to excel. I hadn't really distinguished myself up to then in the Navy and law school at my first firm. I was unknown completely in legal circles. I had no clients and a shaky personal financial condition. I had 3 years of low-grade practice experience, but I joined Skadden as the senior corporate associate, having made my experience sound more impressive than it actually was. There were only 2 corporate partners, and I was next in line to take on important matters. But the firm didn't have an impressive roster of business clients, and they had no regular investment banking clients as such. So I started with some odd stuff like representing a breeder of Angus cattle who wanted to create security interests in a prize bull's semen. And there I was stepping gingerly around the farm in my Florsheim loafers. It didn't seem like what I was destined to do. But the firm had a great sense of ethics and professionalism and an insistence on working hard and doing what Les Arps, the partner, called upper margin work. 2 years later, in 1968, I became a partner, and now let me explain the path I then took. The firm's leader was Joe Flom, who was in large part responsible for Skadden's rise to prominence, and the hostile takeover movement of the 70s and the 80s was right up his alley. For some reason, the established Wall Street law firms, were slow to enter the takeover game, even to represent their victimized clients or to advise investment bankers. So Joe and Skadden Arps, along with Marty Lipton and Wachtell Lipton, got there first, sometimes representing the aggressor, sometimes the target. And we became a major factor in unbundling the cozy relationship that used to exist between big companies and the single law firm that did all their business. Now, in those early takeover days, while a lot of strategizing and litigation maneuvers were going on, a direct negotiated solution between aggressor and target was unlikely to occur. I worked with Joe Flom on some of those early contested situations, but I didn't stay on that path. I wasn't comfortable representing aggressors who forced target companies to accept outcomes they didn't want. It didn't suit my personality. And even representing targets, the opportunities to negotiate a solution remained very limited. I found that what I enjoyed most was to negotiate deals that brought companies together voluntarily. And the most interesting deals to negotiate were corporate mergers and acquisitions, a relatively quiet area then when I first became involved, but one where the parties needed help in arriving at the business and legal terms to make a deal happen. I'll also be candid. A big consideration for me was that if I continued working in Flom's area of expertise, I'd never be the man in major cases. Joe already had that spot and was unlikely to give it up. He was going to remain indefinitely. I wanted to stake out my own area of achievement, independent of him. So I veered off into the more prosaic, seldom print-worthy, and less lucrative field of negotiated acquisitions. And Joe turned from me to a group of excellent younger lawyers to be his first team. So negotiated acquisitions became my major practice area during the early 70s. Later on in the 80s, when I'd already made my bones, I took on the target side in a number of major contested takeovers like TWA and Federated Department Stores, but that's a story for another time. As I got more involved in M&A, and by the way, nobody called it M&A back there. The term was never used. I felt a strong urge to write about it. The existing literature on corporate acquisitions was very legalistic, concentrating on structure, principles of corporate and tax law and such. To me, these tomes missed what lay at the heart of any acquisition, the negotiating process, which was seldom discussed or analyzed. So when I was asked by the New York Law Journal's publishing operation to do a book on the subject, I agreed to do so, but only if I could emphasize the negotiating process. And that became my 1975 book, Anatomy of a Merger, which I'm proud to say became the lawyer's Bible at the time for negotiated deals. And we quickly created a distinctive 2-day annual seminar on how to negotiate corporate acquisitions, which focused on the give and take, jostling of positions that takes place between the parties and especially their lawyers. I had a panel of experienced practitioners. I devised a hypothetical acquisition scenario, and we negotiated with each other on stage for the next 20 years. So that was how I got involved. Now I'm. I'd like to talk about the subject of negotiating, unless you'd let me talk about.
Oh no, I think I think that's great, Jim. I wanted to mention on Anatomy of a Merger, you said it became kind of the Bible of doing mergers and acquisitions. In the 70s and 80s. It's actually, as I mentioned to you, a book that I stumbled across in college. While wandering around the stacks when I probably should have been studying for, I think it was a calculus exam at the time, and I had no idea what a merger was or an acquisition, and just your way of storytelling and sort of inviting me into that very heady, intense, exciting world, I think really led me on my path to pursue sort of similar work that you've done. And the other thing I'm really interested about is, and I mentioned this to you, I don't know if you really believed me, but I told you that if you just took out the tax chapter in anatomy, for the most part, despite all the structural changes and everything that's happened in technology and everything else and how deals are done, it really is spot on even today. And I think the reason is your ability to create frameworks, to take one-off deals that you do, every day and extrapolate, general principles from those, ways of thinking about things in a more general way. How do you agree with that, I guess? And is that something that you cultivated?
Well, that was my style of writing. Anything I did, I didn't. I've written a lot of books, but I haven't researched any of them. I didn't. It's all from experience. It was all from the trenches. I wasn't not philosophical about this stuff, but this was the way it was happening, and I've stayed with that. I've stayed with things that I really knew something about and weren't borrowing from other people. I hope that's the case. They're still selling it. They're still selling the book.
And I guess on the negotiating side, you really talk a lot in Anatomy, but also in a lot of your writings about the importance of sort of being a helpful deal maker, a creative deal maker, being able to, find solutions to problems. And were you always like that as an associate coming up working with Joe, or was that a skill that you just sort of stumbled upon, developed as you progressed?
Stumbled. Here's what happened. I can hardly remember the subject of negotiating ever being mentioned in law school when I was there. And then in practice, after a brief apprenticeship, I found myself in the midst of transactions, which placed a high premium on that particular skill. And I'm sure I floundered. I had no training. I had no theoretical platform to fall back on. There were no black letter instructions to memorize. The seniors that I worked with focused on substance. They rarely paused to instruct me on tactics and the like. And so I began to negotiate. And I made what, in retrospect, were a number of clear mistakes. I ceded points when I didn't have to. I was receiving nothing in return. I became stubborn on issues that didn't rise to the requisite level of importance. Against a patient negotiator, I wasn't as persistent as I might have been. I ignored significant clues that might have suggested paths of favorable compromise, and so on. But gradually, as I did it, I stopped treating negotiating as a legal stepchild and began to view it as something worthy of serious consideration. Because negotiating tends to be somewhat freeform, it doesn't lend itself easily to this sort of thing. As a result, many lawyers, I've found, simply don't bother. They just let it happen. They trust their instincts. And as you might expect, those with good instincts usually turn out to be quite competent at the bargaining table. But what I found was a sad fact that a large number of otherwise skilled lawyers were mediocre negotiators at best. They became so immersed in the difficult substantive questions that they rarely stopped to analyze how best to achieve their goals. They neglected to size up their adversary, peer inside his mind, discover what's really troubling him. They seemed to lack adeptness at devising effective compromise. Their inventiveness was reserved for matters of substance, new ways to structure a deal for tax purposes and the like, while the equally creative, I feel, and necessary task of circumventing a difficult sticking point, that remained ignored. And yet, lawyers, I could see, were logical persons to handle negotiations in these kinds of transactions. Legal mind is invaluable for clarifying situations. For example, to identify the cause of a seeming disagreement as a simple failure to distinguish between separable issues. Lawyers possess the training and experience to ask the hard questions that are so crucial to the bargaining process. It's usually the attorney who realizes that the parties' minds haven't really met on an issue which is seemingly resolved. And although I wrote and lectured widely on doing deals, I was never coming from an academic or philosophical place. Rather, it was the view from the trenches, where I was busy hammering out business agreements on behalf of clients who wanted the transactions to take place. And what that requires, as every business lawyer knows, is a concentrated dose of problem solving and negotiating. Search for common ground to reach effective compromises that permit a deal to move ahead on terms reasonably satisfactory to both sides. There was seldom any ambivalence to the instructions we received from our clients. The clear message was, get it done. That meant finding a way to resolve everything so the deal could proceed. So we eschewed extreme positions. We knew we couldn't stick with impunity on anything less than a real deal breaker. Most of the time, the guy on the other side of the table was operating under a similar Band-Aid. So we yapped a lot at each other and we squabbled over warranties and indemnifications and such, but we never lost sight of the goal to close the deal. Here's what I had to say about the process in Anatomy of a Merger. To call off a deal is no trouble at all, but it requires some real ability to hold together the pieces of a difficult acquisition and accomplish it in a way that satisfies all parties. The adept negotiating lawyer does not allow a seeming impasse to sabotage an otherwise viable deal, but instead devises a workable compromise, which itself can possess aspects of creativity, fulfilling the needs of both sides without subjecting either to serious adverse consequences. Now, the issue is negotiating a big deal like a corporate acquisition were of many kinds. Some are disagreements over money, not only purchase price, but a multiplicity of other matters measurable in dollars. Other things involve less tangible matters, such as covenants and escrows, or abstract concepts like materiality and best efforts. Whatever the problem, the deal maker's attitude has to be that even seemingly deadlocked issues are ultimately solvable. Most of what takes place in the course of negotiations, I felt, could be characterized as either attempting to get a leg up on your adversary or to strike a compromise between your respective positions. And I firmly believe, and still do, that the key to effective negotiation lies in achieving a functional balance between these two seemingly inconsistent aspects. Hey, if all your efforts are directed toward gaining advantages over your adversary, you'll undoubtedly come on too strong. And where the parties possess relatively equal bargaining power with freedom to consummate the transaction or not, you may cause your client irreparable harm, such as losing the deal. On the other hand, if you don't push a little, if you never strive for advantages in drafting or stake out positions that invite rebuttal, then your client is unlikely to achieve his share of obtainable rights and protections. There's a balancing act, and it has various applications. For example, a skilled negotiator should mix equal parts of persistence and perspective. I thought those two go together. Bargaining sessions often spill over into the wee hours, with points conceded that need not have been where the party is relatively fresh. If you have the stamina to persist, more often than not, you'll come out on top. But a failure to temper that persistence with perspective cuts down on your effectiveness. After all, you're not going to prevail on all the issues that arise in a negotiation, so you save yourself for the big one. Let the other fellow win a few also. Don't become mired in the pursuit of trivia, losing all sense of what's significant, generating bad feelings that make it harder to obtain concessions or reach compromises in areas of real importance. And having adopted this principle of balance, if you do, you'll come to realize that the non-negotiable demand school of bargaining is quite inappropriate. In my experience, very few points are really non-negotiable. Some movement is usually possible, cosmetic if not real substantive. Refusing to negotiate around even the periphery of a complex point is less a valid bargaining technique than the absence of technique. Now, don't get me wrong. There'll be times when an important issue has been whittled down to its bare essentials, and you feel the need to take a stand. In such a case, by all means, do so. Just make sure it's a basic point for your side, perhaps even a deal breaker. Don't act out of pique or lust for power. And be sure you're adequately communicated this sense of importance to your adversary so he knows what he is up against. The balance theory also renders obsolete what I term the martial arts of negotiating, threatening to call off a deal, blowing up over a point, stalking out of the room, and other assorted brinkmanship techniques from the hairy-chested school of confrontation. As a rule, this sort of thing just doesn't belong in ordinary commercial negotiations. There are other means than packing up your yellow pads to impress an adversary with the seriousness of your position. And if you do take a walk, make sure it's over a real deal breaker and not some trivial side issue. At times, though, in my case, I must concede, perhaps too often, momentary flare-up may be almost requisite as a narrowly focused expression of disapproval over an unpardonable depredation by your adversary. If the lawyer on the other side has been reiterating a point ad nauseum, you might feel terribly frustrated, but you shouldn't blow up. However, when he tries to retract the concession previously granted, that's another matter. Similarly, when your adversary suffers a convenient loss of memory or misquotes you, he deserves a dramatic memento of his bad faith. And a brief but convincing display of your indignation will signal that he's heading down a dangerous road. I try to send signals of consistency to the other side so they know which are the issues I feel strongly about, and thus are the ones where they're unlikely to move me off the posture I've taken. When you're all over the place, that message doesn't get across. In my book on the subject, Smart Negotiating, I spelled out my concept of what kind of negotiator I was. You've asked me, David, in the past, what is a good negotiator? What should people strive for? There's no one way. I mean, everybody's different. I've never met anybody who negotiated exactly the way I did or otherwise. And you can be very good in a lot of different ways. But here's the way I felt about it. I'm quoting from the book. Just so you know where I'm coming from, I consider myself an ethical and fair-minded bargainer. I'm opposed to misrepresentation. It's the kind of dissembling that seeks to achieve an unfair advantage. I don't believe in chiseling. I scorn dirty tricks. I'm not looking to win at any cost or to make those on the other side feel as though they've lost. I like to base my arguments on reason, have a solid rationale for my positions, and to try to be persuasive. In turn, I'm willing to listen in case the other side's rationale might persuade me. And where possible, I prefer to conduct the negotiations in an atmosphere free of rancor or personal animosity, and to conclude on good terms with my counterpart. Nevertheless, I don't like to end up with substantially less than I consider myself or my client entitled to, based on all the factors affecting negotiations. It's gratifying to end up with more than we expected, and I generally try to land in that territory if possible, but I don't look upon achieving something extra in every deal as an article of faith, as long as we get our just desserts. On the other hand, I definitely do not like to feel that I've been taken advantage of or jerked around. And when my antenna sense this happening, I stand up on my hind legs and let the world know about it. It goes against my grain to see deals muffed that should be made, whether because of transigence, overtrading, miscalculation, misinformation, erroneous assumptions, or whatever. I recognize that some deals simply don't make sense, but when one is itching to occur, I feel a sense of failure if I can't concoct a strategy to bring the two sides together.
Did you feel, Jim, that there was a particular deal or point in your development where you kind of felt, I've got this, or I know it's constant? The one thing great about M&A is it's a constant learning experience. You're never really, you've never really mastered everything. But did you reach a point, either as an associate or when you first made partner along that path, you'd been working with Joe Flom and others, where you sort of came into your style, your approach, and felt good about that, confident about that as you were, taking on more and more work independently?
I think it was when I finished the book, Anatomy, 1975, negotiating for about half a dozen years or so, but I was feeling my way, and the book got me to think through a lot of things that I've been doing unconsciously and come up with some of the statements that I've been making. Then I felt very comfortable, and that's when we started the seminar, and I testing it out on other top lawyers, and I was very comfortable after that. But it took a while. You got to come to it yourself. You can't, even if you read what somebody else has to say, you have to come to it in your own experience.
Well, you used to always say, I think maybe it was Anatomy or someplace else, you said, you can't hand somebody, whether it's Anatomy of a Merger or Smart Negotiating or any of the other things that you've written on it, and say, here's your cheat sheet, here's your guidelines, there you go. You have to immerse yourself in it.
There, you have to get the feel of it. No question about it.
I know we're focused on mergers and acquisitions, and I'm going to lead you down to sort of your commandments, I think, and commandments of negotiating, which I think people will find really interesting if they haven't run across them. But you also do so many different things, from playing tennis to terrific singing and piano playing and photography. I'm wondering, and maybe it's just my observation about it, when you talk about solving problems and being creative and coming up with ways to solve what some people may think is just an impasse, you have a creativity, maybe a flair a bit, the ability to sort of do that, to break issues apart. Do you think that your creativity in the arts and photography and music contributes to that in terms of being well-rounded, having a perception about people, an empathetic approach? Did that contribute to your success as a lawyer, or maybe more specifically as a deal lawyer and negotiator?
No, I'm not sure it contributes to my success that I'm feeling as a person, who was a lawyer and also does other things. I've found too many lawyers who so view their lives so narrowly, they never get into anything else. And when they have to retire, it's sad. At the moment, they'd have nothing they want to do. I was itching to retire when I did retire because I had all these other things I wanted to do. They're separate things. They were separate things, and it worked out very well for me. Full disclosure, I've been out of M&A, except for mediating some post-deal disputes, which I can spend a minute or two on later on, for over 25 years. So, and things have, I know things have changed in the practice, and I wouldn't get into any of that. But I would like to talk, if you think, I would like to talk about what I feel are certain aspects of the practice that I hope are still relevant or should be. What I used to call my 10 commandments of negotiating deals. Is this a good time to talk about that?
Oh, I think that would be perfect and very useful for people, again, who are trying to think of a framework, a way to approach, problems that seem different. And I think the 10 Commandments is wonderful. So yeah, please talk about that a bit.
Okay, some of it may be a little repetitive of what I've said so far, but here's my 10 Commandments. Number 1, make the deal. And never forget that the reason that you're there as a lawyer is to make a deal. That's what the client hired you for, and what he's looking to you for. He didn't retain you to come up with excuses as to why the deal can't be made. Now, sure, you're bound to run into some knotty issues, have no obvious resolution, and along the way, you're likely to engage in some posturing about having reached the end of the road and being paused to take a walk. But don't let the frustrations and theatrics blind you to assessing what needs to happen in order to reach agreement. I firmly believe in the ultimate solubility of most issues if both parties want to make a deal and are willing to bend a little. The second commandment is cover your tail. Hey, notwithstanding the lessons of commandment number 1, not all deals get made, and therefore you must learn how to protect yourself from becoming the object of your client's wrath if things fall through. So if you have one of these seller clients, let's say, who says, come back with this deal, Jim, but don't accept $1 less than $100 million. And you've seen enough to know that the prospective buyer won't pay $100 million. You need to convey that splash of reality to your client so that when the buyer's heads for the hills, you're not left shouldering the blame. Number 3, assess realistic expectations. That's a term that I've used for this. Before the negotiations begin, you have to sit down with your client and help him formulate realistic expectations on price and other key issues. For me, developing a realistic expectation starts out, and there are different ways to come to it, but this is my way, with a hard-headed, I call it aspiration, keyed to objective values, traditional outcomes, no pipe dreams, please, which is then tempered by an assessment as to the feasibility of achieving it. So aspiration and feasibility. That's the expectation, and that should be reassessed as things develop and in light of new information. And that's what you need to have in order to decide where to start out, what steps to take along the way, and most notably, when to stop. The big negotiating blunder I used to witness would occur when executives, investment bankers, and as lawyers too, opened the bidding without any clear idea what they were aiming for. Number 4, recognize and utilize leverage. A prime component of that feasibility analysis in amendment number 3 is evaluating the leverage that exists in the situation. Gather information to help you make the assessment and then take a hard look at such leverage factors affecting your client and the other party as these. Necessity. Is the seller forced to sell? Puts seller at a real disadvantage. The ability to walk away from the table is what puts backbone into your bargaining position. Desire. Who wants to deal more? A real advantage for the cooler party who's more willing to risk losing the deal. Competition. Are other interested parties in the picture? Having other potential buyers puts pressure on the buyer to pay top dollar and stiffens the seller's resolve to hold out for it. Time. One of the parties acting under the pressure of a deadline. Time pressure cuts across all other negotiating considerations. Party acting under a deadline that doesn't impact the other party often makes decisions and takes action that vary from what his conduct would be under more relaxed circumstances. Now, while you're at it, don't ignore apparent leverage. Exerting leverage in negotiation or having it used against you depends to a large degree on appearances. And we all know that appearances can be deceiving and a subject of being manipulated. So don't be overwhelmed by apparent negative leverage factors working against you. The guy on the other side may be subject to elements you're unaware of that hamper his freedom. So at the outset of any negotiation, I counsel always remember to take these initial steps. First, try to gauge your own strength or weakness. If he's strong, make sure your counterpart knows it. If you're weak, work hard to keep him from realizing it. Then, try to gauge your opponent's, your counterpart's actual strength or weakness. Then, surmise whether his perception of his strength or weakness accords with reality. If your counterpart believes he's stronger than he actually is, educate him to the real facts. If he thinks he's weaker than he actually is, don't say a word. Okay, number 5, take responsible positions. Acquisition negotiations traditionally involve positional bargaining. You're unlikely to walk into an M&A conference room where everyone's brandishing a copy of Getting to Yes and gushing about shared interests. In order for both sides to feel satisfied with the ultimate results of the negotiating, there has to be a process, some adroit maneuvering, a strenuous give and take in order for each side to arrive at the finish line reassured that it got the best deal possible and didn't leave too much on the table. So you've got to give yourself some room to bargain. But, and here's my point, you should choose starting points on price and other key issues that don't appear to overreach. They should be sufficiently reasonable to evoke a positive response, while still giving you enough space to end up at your realistic expectation without being forced to stretch beyond it. Now, a prime attribute here is your ability to attach plausible rationale to the position you're taking. The rationale doesn't have to be convincing, and rarely is when applied to an opening or intermediate position, just plausible. If you can't come up with plausible rationale to buttress a position you're about to take on price or some other key issue, then don't take the position. Let this be your litmus test for whether or not the position is defensible. Number 6, keep in balance. As I've said before, it pays to remember that your goal is mutual satisfaction, or else there won't be a deal. It takes two to tango. So you have to bring the other party along. I like to put it in terms of winning him over, not winning over him. I was always looking for the favorable middle ground. My client was pleased with the resolution, and the other party was satisfied enough to do the deal. To get to that place takes good judgment. In my view, the key to sound negotiating judgment is to keep yourself in balance. I said before, balance between what you do to gain an advantage over the other side and what you do to move both sides closer to an eventual compromise. The balance isn't always 50-50, though. Leverage and other factors dictate where to draw the line. Number 7, devise a constructive concession pattern. It takes movement to generate movement. Or put another way, you have to give in order to get. Use the room provided by your opening offer as trading material to lure the other side into constructive negotiations that bring the two sides close enough for you to spring the final compromise. Don't stint on the needed movement or fall in love with your intermediate bargaining positions. You know, the term that's commonly used to describe a typical step in that process is concession, which I think may be an unfortunate choice of words. In other areas, we think of a concession as yielding a right or privilege. It sounds as if you're giving something up, which is how many people approach the process, viewing each step as a tense, grudging struggle. To my mind, that's the wrong attitude to take. The only real concession you make, in the sense of being deprived, occurs if and when you're forced to stretch beyond your realistic expectation. Everything else is simply part of the negotiating dance. Tactical adjustments, if you will, designed to bring you and your counterpart to mutually satisfactory terms. Here's the 3-part message I like to send, either explicitly or implicitly, to the other side when making a concession, when I'm making a concession. First, this one is meaningful, even if it doesn't go as far as he might have wished. 2, but there may not be many more. This message gets stronger as you approach your expectation. And 3, particularly if it's not reciprocated. This message should be consistent from day one. And on the other side, always beware of sending the wrong implicit signal to the other side by the way that you react or fail to react to each of their new positions. If it's bad, tell them so. Don't receive it calmly, or let him infer he's on the right track. Number 8, credibility is key. The biggest credibility issue in a negotiation occurs when one party says, that's it, they know more. Is it genuine or is it a bluff? If you're the one taking the position and it's genuine, you need to convince the other side that you've traveled the last mile. In this regard, how you arrived at that point may be important. So, for instance, in terms of price or other dollar issues, a progressive decrease in the absolute size of your concessions helps set up your final sticky message. You also have to show that the issue is meaningful to you, since people don't usually stick on a sideshow. It's tough to make your stance credible if you take a this is it position on multiple issues. Here's how I put it in smart negotiating, and I like this. I like my own writing this. Just as in art, this gets to your point about the other things I do. Just as in art, where negative space defines form, or in music, where silence outlines sound, so in negotiations, you gain credence for your inflexibility on a few choice issues, your blue chips, by your willingness to give ground on the rest, your bargaining chips. As for bluffing, I advise against it. Not everyone agrees with me, but that's the way I feel. A bluff, here's the way I analyze it. A bluff has 3 possible outcomes, the 2 of which are adverse to the bluffer, which are not good odds in my book. Here's an example. Say you're the buyer and you bluff that you're unwilling to pay more than $90 million for a company where the seller has demanded $100 million. Now, the positive outcome is that the seller believes you, acquiesces, and sells to you for $90 million. Congratulations. The first negative is that the seller calls your bluff, forcing you to pay $100 million and impairing your credibility for the balance of the negotiations. But I'll tell you, if that were the only risk of bluffing, I might favor it as a technique in more situations. It's the second negative that gets me, where the seller believes your bluff that you're only willing to pay $90 million, but is unwilling to let his company go for $90 million. So he sells the company to a third party for the $100 million that you were willing to pay but never got the chance to offer. It's the fear of succeeding with the bluff, but then having it blow up in your face that makes me consider the risks of bluffing unacceptable. Except in one situation, which you have to read my book, Smart Negotiating, page 154. Number 9, forging the ultimate compromise. Forget the negative connotations sometimes attached to the word compromise. In negotiating a deal, a compromise, however messy or inelegant, that satisfies both parties sufficiently to shake hands, is a hell of an accomplishment. Your attitude has to be that you and your counterpart are in this together. You can't just say, for instance, well, that's his tax problem, because his tax problem becomes your deal problem, unless you can find a way to make the transaction palatable to him. For each effective compromise, you need to find a precise number or formulation that does the trick without giving away too much, and then figure out how and when to introduce it so it's viewed as a solution to the problem, not just another position that becomes subject to further negotiating. In this latter regard, beware of succumbing to impatience. A classic example is the premature offer to split the difference when there's still a large gap between the parties' positions, so that in effect, you've moved and he's still where he was. Become proficient in some of the most effective compromise techniques. Learn how to reduce seemingly sacred principles to dollars that can be moved around with maybe a face saver if needed. Figure out ways to divide up seemingly indivisible issues so as to satisfy the other side's real concerns, narrower than those he's expressed, while protecting your essential interests, more limited than those you previously advanced. Structure compromises where Uncle Sam bears part of the burden, allowing the party with the tax break to stretch further and satisfy the other side. Include goods or services, the value of which to the recipient is always higher than the cost to the furnisher. Try to expand the pie, adding some new element to the picture that permits one party who now has more to gain to surrender more than he was willing to previously consider. When several issues remain open, swap between them, or where appropriate, propose a package deal. Okay, number 10, the end of the road. There are two aspects to this final point, which focuses on what needs to happen as things near a possible conclusion or a possible breakup. The first occurs when things are going your way. The other side has already agreed to terms that meet your realistic expectations, but you're trying to squeeze a little more out of the orange. My advice is don't unduly prolong the process. A smart negotiator knows when to stop the music and grab a chair. People can change their minds when new factors such as competition may intervene. When the risk of losing the deal doesn't justify the possible incremental advantage of continued negotiating, that's the time to come to terms. In the old days, I'd frequently find myself whispering to a client late in the evening, don't let this guy out of the room tonight until you've shaken hands on the deal. Now, the flip side is when you're not doing so well, and it becomes clear that you won't be able to meet your client's realistic expectation. He'll have to stretch beyond it if he wants the deal. For this, I recommend taking your client for a figurative walk around the block, trying to isolate the decision from the frustrations caused by the bargaining to this juncture. Then pose the issue for him this way. If the deal was good enough to do at the level of your realistic expectation, Does it still make sense given the needed 5% stretch? Or another formulation, if you stick and lose the deal, will you regret it in the morning? If the answer to either question is yes, then tell them to go back into the room and, however reluctantly, shake hands. If not, sayonara.
Those are just wonderful, Jim. The last one reminds me of, in law school, you'll learn about kind of the hapless litigator who's cross-examining someone and has them, but makes that one final question that allows them to wiggle out of it. And so I think that's a very good point, that kind of when you've accomplished a good deal, wrap it up. Don't continue to grab for that one more thing that you think you might be able to grab. Did you find when you were working with so many associates over the years, I hope, most of them you handed a copy of anatomy and lawyering, by the way. We didn't touch on that, but to me, I don't know if I want to say that's my favorite book that you've done, but I think it's certainly up there with anatomy. It's just a wonderful book for people who haven't, grabbed that. I think that might have been 4 or 5 years after anatomy that you wrote lawyering. It's just an incredible book, not just for corporate lawyers, although it does have your kind of corporate focus, but it's just an incredible book. But when you were working with these associates over the years, were there certain personality types or was it all different kinds could succeed and do well? Or were there certain things that you said, that just kind of triggered you, that person, that she's going to become just an outstanding M&A deal lawyer?
Good question. I'd have to think about that, but it certainly made distinctions in how I felt about the capabilities of different people. I'm not sure what I might be based it on. So for just staying up all night and having a memo on your desk in the morning, that was a great thing. There's a lot of different things that you looked at, and I had a lot of associates that I thought were terrific, and other was, all right, but not great. Very few that were bad. Forget them. Forget about that. I was not an easy boss. People accused me of being much harder nosed than I turned out to be in later life, and I probably was. I played tennis, and I used to walk around the office with a tennis racket swing, and then one day there was a bit of fire in New York that somebody was killed because they couldn't get any air into the room. So I got a baseball bat, and I had that in the room just to break the window if the fire ever came. And I would walk around with the baseball. I could be tough, but I hope I conveyed some points along these lines to these people.
Well, you mentioned, I think in your memoir, I think a story that if I remember right, about Joe Flom. It may have been you were giving a speech talking about Joe, but I gathered that he, maybe that was sort of as you were working on these hostile deals or working with him, he was quite demanding and tough. At least that was the impression I got. Is that?
He was, but he had some special good qualities that were terrific.
And one of the interesting things that I found many years ago was this wonderful vignettes that you did, and I come back to these associate training type things because I used to play that video. I think I found it on some old VHS, cassette that you would have to put in, and it was a wonderful set of vignettes where you and I think it was probably Skadden Associates at the time. Probably many of them went on to to great careers as partners at Skadden or elsewhere, and you were kind of in character in all of these different kinds of situations that an associate, doing M&A or sort of a rough and tumble, corporate practice would run into. Do you remember those series of vignettes?
10 Tough Times, I think we called it, or something. Yeah, it's PLI video. I wonder if they still have it in sale. It was good.
It was very funny, but very informative. And I think people would watch that and you just see them, those who had been in practice for 2 or 3 years, the ones that were maybe our summer associates or first years didn't have the context to put those into perspective. But I would tell them that don't worry, in a couple of years, each of those will have sort of a special meaning to you, and you had great ways of at least conceptualizing, thinking about ways to deal with those common, difficult situations, which haven't changed. That's one aspect of M&A, I think, that you would easily remember, the intensity of it and the need to sort of be firing on all cylinders. And I think you've talked about that, but was that something that you missed? I know you were excited about, leaving Skadden and you left, I wouldn't say early, but you know what I mean? You left kind of at a peak. Did you miss in those years after you left, that kind of, excitement, intensity, the thrill of the deal?
Well, when I left, I wrote an article for Business Lawyer about the 12 dozen reasons that I retired early. In those days, it was retiring early. I was 62 years old, but nobody had ever retired. Everybody looked at me crazy. Why are you retiring? Now, of course, everybody's leaving firms at that time with nice packages and whatever, but no package then. It was I just wanted to get out. But to your specific point, one of those 12 things was that I had really enjoyed in the earlier years, the mentoring function that you're talking about. But what happened toward the end was the guys I'd mentored were now partners, and the people they were mentoring were the younger people who were looking to them, rightly so, and not to me. And nobody was coming to me and asking for anything. And so I lost one of the one of the real reasons that kept me around. Nobody asked me any questions. And speaking of nobody asking you anything, can I say a few words about post-retirement and mediating and such?
Oh, no, absolutely. I think that's, you and I have talked about that. I think that's one of the most interesting things that you've done, and that I think more people, I know you feel the same way, more corporate lawyers should think about, learning about mediating complicated corporate disputes. So absolutely. Please, you talk a little bit about your interest in that and what you've been up to.
So I retired from Skadden in 1996 at age 62. Wanted to spend more time on these other activities, music and writing fiction and photography. But I wanted to have some professional activities. It turned out my principal professional activity after retirement was mediating commercial disputes, which I'd started on in my last year or two as a Skadden partner. I wanted to do more of that once retired. But truth be told, I was initially hoping that another more lucrative area of practice would work out for me. I'll confess to this. Here's what I envisioned happening at comfortable intervals. A sizable company would be hit with an unsolicited takeover proposal, and the company's long-term outside counsel firm was not expert in M&A takeovers, but the company might be reluctant to bring in an M&A firm like Skadden to take charge. However, I surmised they may like the idea of enlisting an unaffiliated guy like me with gray hair and considerable expertise in the area to work alongside their regular counsel. And sure enough, during my first year of retirement, I received just such an assignment from a sizable company, which was then the subject of an unsolicited, unwelcome takeover offer of, I think it was around $500 million. So it was right up my alley, I told myself. And I can still picture the scene on the day when I was addressing the company's assembled board of directors. I did it on a hands-free conference call from my study at home. I was dressed in sweats. My feet were up on the desk. And the words I was spouting were very much the way I found myself talking to target boards in similar situations. You can tell they're ready to shove it with his chintzy $500 million deal. Your investment bankers peg your company a much higher value. They've opined that the offer is inadequate. You have no obligation to negotiate with the rater for a higher offer, et cetera, et cetera. When the call ended, I suddenly realized that there was something different about the situation from the ways I'd handled it before. And it wasn't just me wearing the sweatpants. At Skadden, I enjoyed the protection of a very sizable malpractice insurance policy in case anything went astray. But for a lawyer on his own, the maximum insurance you could then purchase had a limit of $1 million. And here I was, feet up on the desk, advising the board to reject a $500 million offer that might no longer be available to them once they'd followed my advice. Suffice to say, I maintained a much lower profile for the balance of that deal and never took on another matter involving advice in a contested M&A situation. Actually, I haven't taken on many client matters of any kind in retirement. Most of what I've done has been for friends. I did serve as expert witness in several substantial arbitrations. I've acted as an arbitrator in a couple of occasions, but that wasn't my cup of tea, probably because arbitration is so akin to litigation, which is not where I came from. An arbitrator or a panel is, after reviewing all the evidence and assessing the arguments of the parties, renders a verdict on the merits that binds the parties. And when I sat there, and the few times I was an arbitrator, I wanted to get down on the floor and tell the guys what to do. I didn't want to just answer the thing. But in contrast to arbitrators, mediators, they don't render a verdict that binds the parties. And even when the mediator offers a proposed resolution of the dispute, it's just a recommendation. Neither party is obliged to accept. So to have any effect here, the mediator has to persuade the parties to buy into a proposed resolution. And I found that very much in line with what I'd been doing in the deal-making area for the prior 3 decades. And being a professional mediator also didn't carry the same malpractice risk as advising on mergers. So I embraced that activity. I mediated some interesting cases, mostly concerning M&A deals that had later turned sour one way or the other. And I wrote some lengthy mediation articles for the Business Lawyer. Now, the nation's financial debacle in 2008 changed the landscape for me. When financial behemoth Lehman Brothers declared bankruptcy, multiple disputes arose involving how much the firm was owed on the countless contracts involving derivatives that they had. And the parties and their experts were usually miles apart on this issue, a result of ambiguous provisions in their underlying contracts, morals over the applicable provisions of bankruptcy law. And the bankruptcy court in New York appointed me as one of 3 mediators to try to resolve these Lehman cases without resorting to litigation. And over the succeeding half dozen years, I handled about 50 such disputes. It was demanding work. I'll never forget one of my earliest cases where the bid and ask was $1 million and $100 million. But it engendered a real sense of satisfaction when I could help the disputants reach a reasonable compromise resolution, as I did in that case just cited. In the early years, I was able to accomplish this most of the time. It grew more difficult later, dealing with the tougher cases that had resisted their resolution. And during the busiest years, I probably spent an average of about 30 hours a month on this work. Nowhere near full time, but significant time commitment that resulted in substantial fees. And during that time, I wrote a book on the general subject entitled Anatomy of a Mediation, a dealmaker's distinctive approach to resolving dollar disputes, other commercial conflicts. It was the dispute resolution sort of bookend to Anatomy of a Merger, a deal making written 40 years earlier. I guess I'm very proud of that. I don't know of anyone else who's so directly expressed in print these disparate issues, making deals and resolving disputes. But that was the pitch of my book. When you get involved in a dispute, you need a mediator who knows how to make a deal, and that's what I've been doing for so many. I won't go into detail here about my mediating style. Let me just say that unlike many seasoned mediators who limit their involvement to playing a facilitative role between the parties, I take an unabashedly activist and evaluative approach. I prod the parties toward a feasible settlement, and if this proves unavailing, I try to persuade them to come to terms based on a resolution of the dispute that I propose. But anyway, that was the main professional thing. I taught at law school for a while, but that was the main professional thing I did.
And of course, I think I alluded to, and we talked a little bit about that. You've kept up your interest in tennis, and of course, photography and music, and I also think you've been writing some plays or shorter fiction.
I just wrote a novella, my first novella, and I'm very happy. I'm very enjoyable. I'm a little disappointed nobody comes to me and asks me for views on anything except you. Thank you. But when you're nearing 90, everybody else is dead.
Well, I do, appreciate this. I think everybody, especially the 10 Commandments, but everything, Jim, that you've written, all of the PLIs, the vignettes, just the 1,000,001 things that you've done, over just an incredible career. I don't speak for myself. I know when we've talked, you I think you might be skeptical, but whenever I mention to deal lawyers, M&A lawyers in particular, that I talked with you, or, that I'm hopefully doing a podcast with you, people are, one, they're in disbelief. They think I may, be delusional about that. But then second, once they get over that, they have just the most incredible stories to tell about their experiences with your work. So I guess I would just say I think I can say on behalf of, all of them, all of us who sort of have come, after you, thanks for just the incredible, writings and teachings and, generosity that you've shown to just thousands of lawyers over the years. And it's just, for me, it's obviously been, very personal, my own development and sort of my own career that I've tried in some way to emulate, as much as one can do that, someone else. So I just want to let you know that. And I've heard that it's never good. And I actually wrote a little post about this yesterday about people were telling me it's never good to meet one of your heroes, somebody that you look up to. And I think the rationale is, you'll be disappointed or somehow let down. But you've never let me down in any time that we've talked or anything else. So I just want to thank you for that. And thank you so much for doing this.
I appreciate that very much. That's very warm, and I love it. Let me close with a story, okay? This is one of my favorite negotiating stories. It happened during a late night in my office a number of years ago. I was still practicing. My client and I were engaged in a very tough negotiation. I think it was an M&A deal with the principal on the other side. His lawyer was outside, but he'd okayed that we talk to the principal without him. Let's call him Larry, the guy on the other side. And Larry was giving us fits. I can't remember what the issues were, but it was. So at one point in the evening, we were in my room, we were doing it. And while the outcome was still very much in doubt, Larry happened to notice on my coffee table a book that I'd written on negotiating deals, probably anatomy or maybe smart negotiation, I don't know. He flipped through the pages, he picked it up, and then he asked if he could have a copy. Oh, absolutely, I said, but not until the evening's over. I don't want to hear my own stuff coming back at me. And what's more, when I give it to you, I'll even autograph your copy. So we continued to negotiate, making a little progress, but still not getting all the way home on one key point. And then it hit me. I scribbled something on a piece of paper, and then I wrote something else on another piece of paper. I turned to Larry and I said, look, Larry, if you see the light and come around to this very logical resolution of the issue that our side is advocating, here's the inscription I'm going to write in your copy of my book. And I handed him the first piece of paper, and it read something like this: to Larry, a wise and consummate negotiator who has mastered the art of extracting the essence from the situation while not letting himself get bogged down in trivia. On the other hand, I said to Larry, if you stick to your absurd position, then here's what I'm going to write. And I handed him the second sheet of paper, which read as follows: to Larry, a bundling, inflexible bargainer who would rather stand on an invalid principle than reach out for the good deal laid at his feet. And I said, well, Larry, what'll it be? And Larry eyed me quizzically, mouthed a kind of a hollow laugh, looked over at my client, and left the room to talk to his lawyer. And 15 minutes later, we had our deal. And it cost me, Lord, forgive me, just one little white lie about Larry's negotiating prowess.
That's a wonderful story. Jim, thank you so much. What a great way to end it. Thank you so much for doing this. I know I've cajoled you a bit to do it, but I really appreciate it. And thank you so much.